What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to break down what just happened in the Brian Kohberger case. We know there's been a slew of motions to suppress different things, accusing the state, law enforcement, FBI, everybody of wrongdoing, trying to suppress all sorts of information that may make most of the state's case go away against Brian Kohberger. Well, the judge said no across the board, denying everything. We're going to talk about why. We're going to talk about whether we agree with the judge or not and what this means for Brian Kohberger and team going forward in trial. Is it as bad as it sounds at this point? And of course, answer all of your questions. So let's get to it. So usually I have a pretty good idea about how long a video is going to go. Today, I don't. Because there's so much information packed into these orders. I'm going to go over three of them today. The fourth one I wasn't able to get to between yesterday and today. It's like over 100 pages altogether. And I'm not going to read all 100 pages. I'm going to try to summarize, but I am going to read you some parts of the orders to give you an idea of exactly why the judge came down the way he did, kind of across the board, because some of the reasoning he gives is similar throughout. And once he starts to give a certain kind of reasoning, you start to know exactly what's going to happen, exactly where it's going to go. And we absolutely get an idea of how the judge views this case. We've seen some other cases, I won't mention any names, where there might be some law enforcement corruption. There may be some prosecutorial misconduct. There may be both. And some cases have a lot of evidence and a lot of inferences and a lot of things that may make you believe that and think that actually could be true and want to learn more. There have been other cases where those types of things are accused and they're just flat out wrong, or there's no basis and there's no reason for really those accusations. Well, the judge is going to tell us what he thinks of some of the accusations made by Kohberger and his team throughout these orders. I also want to talk about how important it is to understand where we are in the process and why these things are important to the defense. Because some of the things that the defense is going to argue here that I think are a major issue with how certain law enforcement or prosecutors acted, mostly law enforcement and some of this stuff, it's going to be hard to make that same argument seem good to a jury. This is the time to make that argument and win on legal grounds, still arguing some facts because the judge is the fact finder throughout this process right here. But even though they may be very good arguments now that the judge had to consider seriously and end up making a decision, they are not as strong of an argument if and when we get to a jury in this case. And I'll explain why and why things are just so different once they get over this hurdle. And now we're looking at potentially them coming in front of a jury, because that's what we're here for, right? To determine if evidence is going to get suppressed or if certain warrants were bad warrants, which means everything that they found is fruit of the poisonous tree, which then would eventually get suppressed. That's what was at stake here. That's what was at stake here. So let's take a look first at, and I kind of did them in the order of the motions that I found most interesting, I think. All right, so we're going to start with the order on the defendant's motion to suppress the genetic information. So this is involving, and a lot of these motions involve the IgG, the DNA, the DNA databases, the gathering of the DNA, how they got it, where they got it, what rules did they violate, and is that enough to suppress any evidence or give a Franks hearing on some of these issues we're going to read about today. So we're going to start out and read the introduction to this just so everybody understands what this document is about. The defendant is charged with 1 count of burglary, 4 counts of first-degree M. It is alleged the defendant entered the residence at 1122 King Road in Moscow, Idaho, in the early morning hours of November 13, 2022, and ended the life of Madison Mogan, Kaylee Gonsalves, Ethan Chapin, Xana Kernodle with a knife. Left at the crime scene was a knife sheath from which single source male DNA was extracted. Using forensic, investigative, genetic genealogy, law enforcement was able to identify the defendant as a possible suspect weeks after the crime occurred. Subsequently, law enforcement conducted a trash pull from the defendant's family residence and obtained DNA tying the defendant to the DNA found on the knife sheath. Defendant was subsequently arrested pursuant to a warrant and charged with this matter. By the way, I opened up the video to say, I don't even think I finished this thought. Usually I have an idea of how long the videos are going to go. Today, I don't really. Hopefully it's around an hour. It might be 30 minutes. It might be an hour and 15. That's about as max as I got. But we're going to get through as much of this today as we possibly can. The defendant asserts that law enforcement violated his constitutional rights by failing to secure a warrant before conducting the IGG and trash pull. He seeks to suppress all evidence obtained through these searches, as well as all evidence obtained through subsequent warrants as fruit of the poisonous tree. The state disputes that defendant's constitutional rights were violated. So at this point, the defendant is arguing that what they did with the IGG and the trash pull was unlawful and violated his rights. A suppression hearing was held on January 23rd, 25, during which the court received testimony from members of law enforcement and experts in IGG, each of whom the court found to be credible and reliable. Following argument, the court took the matter under advisement. The court finds the defendant has failed to demonstrate his constitutional rights were contravened by IGG and trash pull, and therefore suppression is not warranted. The standard of review of a motion to suppress is bifurcated. The power to assess the credibility of the witnesses, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court. So, I mean, the court in this situation is determining fact and law. Fact and law. So then they kind of go into what his findings of facts were. And just to summarize what his finding of facts were, he basically found that law enforcement got a single source DNA, used private databases to kind of search through and see if they could find a match. 2 of those databases permitted law enforcement use. However, 2 of them reportedly disallowed it. And that's going to kind of become part of the issues we're dealing with here. He definitely throughout this takes the state's point of view of the facts, saying law enforcement used proper means, did not search out inappropriate information while trying to match the DNA. They had 4 low matches, couldn't get it done, turned the investigation over to the FBI. The FBI then spreads a wider net and used the databases that, again, purportedly disallow their use. Now, there was a lot of argument about whether or not the FBI should have used these databases that say they don't allow law enforcement to use them. But additionally, DNA gives you a lot more information than just identification. In the past, the case law is pretty clear. You can use certain things for identification purposes only, but other things they've argued, if you get way more information, then that's too much and you're violating people's rights. And they have certain privacy rights and expectations of privacy in those items. But the court here says he basically finds that law enforcement just used it for identification purposes, and that's kind of within judicial discretion. So it is what it is. All right, let's jump to page 4 here. The Idaho State Police then turned the information over to the FBI, which was able to use Othram's profile, which that's one of the companies that did some of this DNA search, and to develop a significantly larger SNP profile. The FBI, and he explains how SNP works, what it is, how you create it. We're not going to get into all those details. We've already read motions on it. We've heard experts testify about it. I'm not going to take up the time in this motion to even try to explain to you what it is, figure out if it's true. The point is, this is how the expert testified, and this is what the judge took as being true and as being a fact. The FBI uploaded the larger SNP profile to multiple genetic genealogy databases, including GED Match and MyHeritage, which purport to disallow law enforcement searches. At the time, the FBI had an interim policy issued by the United States Department of Justice related to IGG analysis and searches by its agencies. On the one hand, the interim policy required that investigative agencies conduct IGG searches in genetic genealogy databases permitting law enforcement use. So they had their own internal policy that they would only use databases that allowed them to use it. Seems obvious, seems like what they should do, seems like people entering in or maybe picking what website they're going to use and not going to use, that could come into play, right? But on the other hand, the interim policy required the investigative agencies conduct IGG searches However, on the other hand, the interim policy also stated it was intended as internal guidance and did not oppose any legal restrictions on investigative agencies, noting the interim policy is not intended to, does not, and may not be relied upon to create any substantive or procedural rights or benefits enforceable at law or in equity by any party against the United States or its departments, agencies, entities, officers, employees, agents, or any other person in any matter, civil or criminal. This interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. From the information it acquired through the database searches, the FBI was able to build a family tree and arrive at a potential match. On December 19th, the FBI provided the defendant's name to Idaho law enforcement as a possible source of DNA. The FBI instructed that the identification of the defendant as a person of interest was to be considered solely as a tip. No warrant was obtained for the FBI's work, and subsequent warrant applications did not include the IgG results to inform probable cause. So let's talk about this now. So, and this is where we get into the nitty gritty of legal arguments versus factual arguments. So, number one, the FBI has a policy. There are certain websites that allow FBI to use it, and law enforcement to search it. Other ones that say no. Okay, that's number one. The FBI has an internal policy that says only use the ones that say we can use it. Don't use the ones that say we can't. Why do you think they have that internal policy? Right? And I think we can ask that question. Why do you have that internal policy? Well, because we're trying to protect people's rights and respect people's privacy. Okay. But they also have a qualification that we can break our own rule if we want to, and we're not trying to add to what anybody's rights are. So therefore, they broke their own rule, and the judge finds that that's okay. They're allowed to break their own rule because policy does not become law. And there's a couple different ways to look at that. Number one, we can look back to the Sarah Boone case. And if you remember, we talked about the Miranda cards. If the Miranda card of the law enforcement agency is not perfect, it does not create any additional rights for a defendant. The rights are what the case law says, what the statutes say. So I understand it from that point of view, that you create a situation where you're trying to create best practices, but you don't necessarily meet those best practices. It does not mean you violate the law or somebody's constitutional rights. And that's what we have here. So what I will say is, I hate it. Why have the internal policy if you're not going to follow it? But I understand where the judge came down on this. I'm not sure I would have come down the same way, but because he has, I do think it's within his discretion. And now let's talk about for a second the difference between arguing this in front of a judge, which is what we're doing now, and arguing this in front of a jury. Judge, law enforcement stepped on my client's rights. You are a lawyer, judge. We are here to protect constitutional rights of accused. This is a constitutional right that's been stepped on. Can you make sure that we fix this and make sure they're not allowed to use anything that they got violating their own internal policy and my client's constitutional rights? Judge says no. Now you take it to a jury and you say, members of the jury, they picked up some DNA from a knife sheath that was at a crime scene. They put it through these websites that they really shouldn't have put them through. Even their own policy says they shouldn't have put them through. But they still did it. Can you believe they did that? That's horrible. Law enforcement bad. FBI bad. And then the state gets up and says, did you hear the defense argue that the DNA didn't match? Because the DNA did match. And it was in those websites. And people went on those websites. And the FBI even has in their policy, if they need to, they can go look at those websites. And that's exactly what they did in this case. They went and looked at those websites, and they were able to match up this DNA. And that's how they caught the guy who did it. UG Minning says, I work FIFO in remote Alaska, 20 on, 10 off with 13 to 15 hour shifts and 90 minutes free daily. I use that time watching your channel. I rarely catch live sessions, but I wanted you to know that your work is truly appreciated. Keep up the amazing work. UG, thank you so much. And today is exactly the type of day I need it, when I was trying to cram in reading 100 pages of a case that is not even my own case, working on, when I had breaks to eat lunch and at the gym and last night to try and read all this to prepare for today's video. So I appreciate you appreciating me. So you can understand the difference between arguing this to the judge and arguing it to the jury. And we are going to continue that discussion because I think the defense experts were good. I think they make some good points. I think this is bad that the FBI is violating their own policy, but now that the court has decided not to suppress it, this argument, I don't personally think, is going to hit as hard in front of a jury. And frankly, the defense is going to have to pick and choose which of these arguments they even want to make to the jury. Because if you try to say, prosecutors bad, FBI bad, cops bad, and this is the best argument you have, most jurors are going to be like, we want to get the bad guy. So we don't really care if you go and look at 23andMe or whatever website you look at. We're glad you went and got the bad guy. That's kind of what that's kind of what I think a jury would think when they get to this point. It doesn't make it right, but that's pretty much what I expect them to think at this point, which is why this is such a big deal. Because people are going to be able to argue, and there's going to be a lot of people online. There's going to be a lot of scientists, a lot of lawyers, a lot of experts discussing how unreliable touch DNA is, how unreliable these experts are, how the DNA or the defense experts are way better than the prosecution experts. Fine. That's all good. But when a jury's sitting there, as we find out every time we hear a jury interview, once they say, I'm an expert and this is how it works, and I'm telling you, this is the guy that was there, he matches the description, we'll get to all that later, and they start stacking up evidence and they say Sheath was there, DNA matches him, who else could it possibly be? That is what you call strong and damning evidence against Bryan Kohberger. That's what you call that. That's why it is such a big deal here today, what happens at trial. Because obviously, if you strike the DNA, this becomes a much, much weaker case for the state, in my opinion. He says he agrees that law enforcement did a warrantless search of the trash, even though there's a county ordinance which stated only authorized trash collectors could collect it. And that's, again, how they match the dad's DNA as the biological father. Then they swab Kohberger, they get his DNA, and that's how they match it. So one of the questions is, did they violate his Fourth Amendment rights with the development of the SNP profile? The answer is no, and we'll read a little bit why from the judge's perspective. This is a matter of first impression in Idaho. However, applying well-settled principles of Fourth Amendment law, the court finds no constitutional violation. First, the defendant abandoned any privacy interest in his DNA by disclaiming the knowledge or ownership of the sheath from which the DNA was extracted. Second, even if no such abandonment occurred, there's no reasonable expectation of privacy in DNA found at a crime scene, which is subsequently analyzed to identify an unknown suspect. So the defense tried to argue that they violated his right because he never said they could search the knife sheath. It's like, well, you also said the knife sheath's not his. So Bryan Kohberger can't say that they can't search my cup if I let them search my cup. Or if they find my cup at a crime scene and they don't say that it's Bryan Kohberger's, right? So that's number one, that's a problem. Number two, you don't have an expectation of privacy at a crime scene. So if your DNA is at a crime scene, that's an issue. It's kind of like if you leave something at a public park, like your DNA, if you touch a public bench, they're going to be allowed to search that. It's different than if you leave DNA in your house or something that you have an expectation of privacy with. So from my perspective, I understand that reasoning with the court. However, we are going to get to the analysis of how the court determined that it was also no big deal that they violated a local ordinance. So far, the judge has said that it is totally fine that the FBI violated their own internal policy. And he's about to say that it's totally fine that law enforcement violated a local ordinance. Let's see. All right, page 10. Likewise. Well, I said page 10 starting with likewise, and I don't see a paragraph starting with likewise. Let's see here. It's not a good sign. Here we go. Page 12, likewise. Likewise, here, at some point, the defendant apparently interacted with the sheath to a sufficient enough degree that he left his DNA thereon. Whether he knew he left his DNA behind is of no consequence. It is only relevant that he exposed his DNA to the public by leaving it on the sheath, thus forfeiting any reasonable expectation of privacy in the DNA left behind. So you start to get an understanding of how the judge is looking at the facts. He says the defendant interacted with the sheath to a sufficient enough degree to leave his DNA thereon. So he believes, based on all the evidence and testimony that he's got, that the defendant interacted with the sheath and his DNA is on it. And that's going to be important because that affects how this judge looks at everything going on in the future. Does this judge think there's enough here for probable cause for Bryan Kohberger? Obviously. And he is going to hold that opinion up and above basically everything else. All right, let's jump to paragraph 14 or page 14 here. However, these cases lend no support to the defendant when applied to a specific circumstance presented here for 3 reasons. And this is why the defendant loses, right? He goes through a ton of different cases. And by the way, these are all on the Idaho court website. If you want to read through all the cases he discusses, it's a very well thought out, well written. He seems like a very smart judge. He seemed like he has a position in this case, I will say, but he seems like a very, very intelligent judge, and he's going to be holding the defense to everything here. And I think that Judge may have done things a little bit differently, but this judge is making some decisions. Number 1, there is no reasonable expectation of privacy in identity. The defendant has not shown his DNA was tested for anything other than identifying purposes. And even if the DNA analysis revealed sensitive personal details, there is no reasonable expectation of privacy in crime scene DNA. So all the different arguments the defense makes, he says, you lose here, and you lose here. So every which way you can lose, you did lose. Because even if you wouldn't have lost here, it wouldn't matter. On number 2, it wouldn't have mattered because of number 3. Here, the defendant provided no evidence that the S&P profile developed from Cube 11 through IgG revealed any genetic predispositions or physiological or medical conditions. Because again, like I mentioned earlier, one of the defendant's arguments was you can only use it for certain reasons, and you get so much more information from DNA than you were to get from other things that have a less of an expectation of privacy. And the judge is like, no. I think the cops only used it for the appropriate reasons, but even if they didn't, it would still be okay for all of these different reasons. As Mr. Hellwig testified, the SNPs that carry such sensitive information are not targeted or revealed in IgG because they are neither relevant nor probative nor appropriate to the identification process, which is the goal of IgG. Okay? So it's kind of like, just trust us. We didn't do it because we don't need to. Rather, IgG only implicates those SNPs associated with ancestry and genealogy in order to determine genetic associations, build a family tree, and identify potential genetic relatives of uploaded SNP profiles. It is simply an identification tool. In this regard, Carpenter is unavailing authority, as has been found by other courts addressing the issue of privacy interest in DNA generally. This is also all important because this is all a case of first impression. Like this is novel. This is new. This is something they haven't dealt with before. And so the judge is making sure that he is documenting everything, all the case law, where he's coming up with, what cases he thinks are the same, how he can analogize these or differentiate cases that the defense said. And that's basically what he did throughout all these motions. He differentiates basically every case the defense cites, and the state's witnesses and testimony in cases. That's what he uses to build out his order. The CLSI in Carpenter was not used as an identification tool. It was used as a comprehensive surveillance tool after a suspect had already been identified. So that was the case where the defense was trying to say, because this case said it, you should throw it out here too because of all these extra things that you can do with DNA. And they said that the judge is basically differentiating it. At best, Carpenter can be applied to technologies that provide the government with comprehensive surveillance of known persons' physical movements. This is not the type of information that DNA provided in this case. The law enforcement here extracted and analyzed the DNA of an unknown suspect solely for identification purposes. It provided no information as to the location of a known person and does not begin to approach the surveillance described in Carpenter. Maria said, will you please cover the Michigan case of the mom who abandoned her kids for years? I don't know. I need a case name, maybe more than that. And I'll see, again, like any case, if you guys are interested in it, all of you guys let me know in the comments section and the chat and by hitting the like button here on this video, and we will dive into anything you guys are following. He even cites cases that say things like, we only used it to identify the killer. And that's exactly what I expect for them to say at this trial at some point. Crime scene DNA is different than other DNA. I agree with that. Let's jump down to page 20 here. In sum, okay, so this is the summary of the judge's thoughts here. The defendant's arguments find no support under the law. Any privacy interest he can claim in this DNA was abandoned along with the sheath, to which he claims no ownership or knowledge. Even if no such abandonment occurred, it's like you lose for this reason, but even if you didn't lose for that, you lose for this reason. The defendant has not demonstrated it is reasonable to recognize a privacy interest in DNA left at a crime scene, particularly when it is analyzed for identification purposes and nothing more. Further, to find the defendant retained a reasonable privacy interest in DNA left at a crime scene, indeed, on an item intimately associated with the suspected weapon, would have the untenable effect of eliminating the use of abandoned DNA as an investigative tool. As observed by the United States Supreme Court in King, this tool has utmost importance since the first use of forensic DNA analysis to catch horrible people in England in 1986, law enforcement, the defense bar, and the courts have acknowledged DNA testing's unparalleled ability both to exonerate the wrongfully convicted and to identify the guilty. It has the potential to significantly improve both the criminal justice system and police investigation practices. Neither society nor this court are prepared to go where the defendant seeks to take us. Therefore, because the development of the SNP profile did not contravene defendant's Fourth Amendment rights, suppression is not warranted. So he's looking at an overall big picture public policy argument saying, if we do what the defense wants us to do, basically we'll never be able to use DNA ever again. And that's not what we want. We want to be able to use DNA. We've had people exonerate on DNA. We've caught the bad guy with DNA, and that's what they're trying to do here. And generally speaking, on a public policy position, I agree with that. I absolutely agree with that. Here's what I'll say. I wish we could live in a world where law enforcement did not have to violate their own policies and local ordinances to catch the bad guy. And maybe you're saying, oh, Peter, that's, living in utopia. It's fine if law enforcement can bend the rules or break the rules a little bit. Who cares about county ordinances? Who cares about what these databases say that they permit law enforcement use or not? And I'll tell you why it's important to me. Number one, I want people to know, people like you, to know what to expect. If you sign up for a website that says, we don't let law enforcement search this, you should get that. That expectation should be satisfied. That's number one. Number two, if you choose to, because some people do. Some people read all the fine print before they sign documents. Some people do all sorts of things. So if you choose to live in an area where they have an ordinance that only authorized waste pickup can get your trash, then that rule should be followed. There are other ways. There are ways you don't have to break the rules to get there. Do I think these breaking of the rules by law enforcement was egregious and the worst kind of broken rules? Maybe not. It is egregious. Is it the worst kind? No, unfortunately, we have cases where it's much, much worse, where we've talked about it together. But this is how we get to those cases. Think of whatever case it is where you think is the worst police injustice or prosecutorial misconduct, whether it's, whether you think personally it's Richard Allen, Karen Reed, Young Thug, whatever, right? Whatever case pops into your head when you think about that. This is how I think they get there. It's by breaking the rules in smaller areas and in minor ways, and judges and prosecutors not caring and just continuing forward and saying, it's no big deal. It's more of a suggestion not to search those websites. But when you start to break the small rules, it becomes easier to break the bigger rules. And that's why, and Susan said, I would rather this person be caught. I get it. Until you think, maybe it's not the right person. Maybe they don't have the right person here, but they can sure as heck make it look like the right person. And maybe they can have a piece of evidence that shows up a few days later. Or maybe they can lock somebody in a cell until they confess. Or maybe they can just prosecute a case and add all sorts of charges and make the case take 3 years in hopes that a jury will convict. Or maybe they can put somebody on the stand that's basically a proven liar, because most of the time the jury comes in and says a crime was probably committed. And will the jury convict? That's the problem I have, right? That's the problem I have. And I agree. I want bad guys to get caught too. I'm not saying I don't want bad guys to get caught. I believe you can still catch them and follow the rules. I truly believe that. I truly, truly believe that. I do not think it's one or the other. What's the point of rules then, right? If the cops say this is the guy, then why do we have any rights? What does it matter? Because you want them to catch the bad guy, right? I'm not saying that to anybody specifically. I'm just saying thought exercises, right? Okay, next, the trash pull. However, the defendant filed this motion. Let me see, am I on the right page? Yeah. The defendant filed this motion. The Idaho Supreme Court has reaffirmed its holding. So this is why he's saying no big deal to the local ordinance being violated. The defendant filed this motion. The Idaho Supreme Court reaffirmed its holding in Donato and rejected the very argument asserted by the defendant here, i.e., that a local waste management ordinance can create a reasonable expectation of privacy. An objective expectation of privacy is not created simply because an ordinance aimed at maintaining society's interest in sanitation dictates how trash is to be collected. As for the subsequent DNA testing of the discarded items, relevant here is the abandonment theory. So basically, the court's saying this is what the law is in Idaho. It doesn't matter if the local ordinance says that only waste management can take your trash. Law enforcement can still search it, because the reason that local ordinance exists is not to create an expectation of privacy, but is instead aimed at maintaining society's interest in sanitation. And I get it. And I agree with that. And I think that that should not be something that should suppress the evidence personally. Because most of the time, trash is seen as abandonment. You abandon your DNA, whatever you throw in the trash. And most people know law enforcement can search trash in different ways in different jurisdictions. So while I do agree with this and I get it, I just don't like to stack up rule bending. You know what I mean? That's kind of what I'm coming down, where I understand. I don't think this is like a horrible injustice by the judge. I don't think this judge is corrupt. I think this judge looked at it. I think this judge weighed it. And in his discretion, he said no. And I get it. And frankly, I'm not so sure how horrible of a decision I think that is, right? I just wish the FBI and law enforcement wouldn't do this in the first place. But the judge can't control that, and the judge has to make the decision that he thinks is right. And that's what he did here. I get it. I know that the trash company came and picked it up, but the court even said they had a warrantless search from the trash that basically was not what the local ordinance said was going to happen to the trash. But I agree with the judge, and that's not the purpose of the local ordinance, right? That's really what it comes down to. Supposedly, anyone in the country could be identified by their DNA, with only 2% of the population DNA samples in GED match. Interesting. Netwoman says, does trash ordinance apply to police, or is it referring to the public digging through trash? Thank you for spending your free time on this for us. It's much appreciated. So this is a hard question because lots of different jurisdictions have different rules. Like if it's a crime to dig through somebody's trash and take it, or if you can just take something from the side of the road because somebody's abandoning it, and you can take a chair or a piece of furniture. One man's trash is another man's treasure, as they say. But in different jurisdictions, what I'm saying is, if we have ordinances and rules in place and people live by those rules, they should be respected. And if not, we've got to have judges make decisions like this. And I think the judge made the right decision on the trash at the end of the day. That's how I look at it, I should say. This court is bound by the decisions of the Idaho Supreme Court. There are no facts presented here that meaningfully distinguish this case from Donato, that the garbage cans may have been placed in the Kohberger driveway for collection as opposed to on a public road, and that Kohberger's neighborhood was gated are legally irrelevant factors given that the garbage was placed for purposes of having it collected by another. Finding no reasonable expectation of privacy in garbage placed out for collection, regardless of whether it was in or outside the defendant's curtilage. Privacy interest in trash is lost when it is deposited in the area particularly suited for public inspection and public consumption for the express purpose of having strangers take it. Therefore, the trash pull did not contravene the defendant's Fourth Amendment rights. Generally, I agree with that. All right, let's see what the next section is here. All right, next is the databases here. Let's go to page 22. The court has already determined that the defendant failed to show a legitimate privacy interest in the challenge to the development of the S&P profile. If the defendant does not have a reasonable expectation of privacy in the S&P profile, there is no basis to find an expectation of privacy in those portions of his SNP profile he shares with genetic relatives. However, to the extent the court's prior conclusion does not dispose of the issue, defendant's assertion lack merit because, number one, the defendant has not shown a reasonable expectation of privacy in any of the commercial genetic genealogy databases or in his relatives' DNA. Two, any alleged violation by law enforcement of its own policies and those of the database is not of constitutional importance. Defendant also lacks standing to object to the testing of his father's DNA, as it is not his own. However, even if he had standing as to his father's DNA, the fact that the item carrying the DNA was voluntarily placed in the trash can for collection results in abandonment. And this is not a novel issue, right? The IgG stuff, the S&P profile, that stuff's pretty novel, new, but from my perspective, the trash stuff is kind of an easy answer. All right, let's jump to page 24. Other than claiming that Hartman Court failed to appreciate its holding, the defendant has not offered any basis. So this is just kind of him hammering the defense and saying, you make these arguments, you make these conclusory statements, you cite cases where they don't even stand for the proposition that you want. And then you say, well, they didn't appreciate their holding, or they did the analysis right, but their finding was wrong. This is what the court has to say about that. Other than claiming that Hartman Court failed to appreciate its holding, the defendant has not offered any basis or even a reasonable analog from which the court could make the unprecedented finding that he has a privacy interest in someone else's DNA. While he may share segments of this DNA, it is not his own DNA that was searched in the genetic databases. Further, there is no evidence he took efforts to shield his genetic relative's DNA from public view. Thus, since he cannot establish a personal expectation of privacy in this item searched, he cannot challenge the search. And then we'll read another summary paragraph here. The point of this, of reading through these orders, I really wanted to get what the judge's answers are and what his orders are, right? That is the important part. In sum, even if the defendant could vicariously assert constitutional rights of others, a dubious claim at best, he has not shown that any subjective privacy right he may have had in his relative's shared DNA was reasonable. Therefore, the defendant lacks standing to challenge law enforcement search of the genetic genealogy databases. By the way, were any of you guys, let me know in the comment section, were any of you surprised at any of the court's rulings? Because I will tell you, after listening to everything, after listening to the experts, after listening to the arguments, this is exactly what I expected to happen. I think the defense has some decent arguments. I think there's some stuff that makes me feel, and I hate it, and I wish it wasn't like that. But does this rise to the level where the court's really going to suppress evidence of this magnitude with this type of a crime, with this many victims? I just never thought it was going to happen. I just never really thought it was going to happen. And frankly, I thought some of the arguments sounded better in writing than they came out in court with the witness testimony and the lawyer arguments personally. That's just how I felt. All right. Page 27. With regard, so this is a paragraph that does kind of make me go yikes. Even having said all that, this makes me cringe a bit. With regard to the FBI's alleged violation of its own policies or guidelines, the state correctly points out that the non-compliance with a law enforcement policy does not provide a basis for a Fourth Amendment challenge. And while that is technically correct, I always hate that. I wish law enforcement agencies and the government would abide by their own policies, just like I think private companies and corporations should do the same. And when they don't, they get sued and they usually lose, because what's the point of having a policy if you're just going to break it? Police enforcement practices, even if they could be practically assessed by a judge, vary from place to place and from time to time. We cannot accept that the search and seizure protections of the Fourth Amendment are so variable. In addition, the point is, lawyers and cops write these policies based on what they think the constitutional rights are. In addition, the interim policy at issue here expressly states that it is intended to provide internal guidance only and does not create any substantive or procedural rights or benefits or impose any legal limitations on otherwise lawful investigative techniques. Therefore, violation of its terms cannot alone give rise to the Fourth Amendment challenge where, as the court has already found, the search of the database was otherwise lawful. It's almost saying that part wasn't lawful. Suppression, therefore, is not warranted with regard to the database searches. So again, from my perspective, it's like, what's the point then? Right? Why even have it? All right. Let's next jump to, what is the next one I have here? The motion to suppress the arrest warrants. Is that what I'm going to do next? Yeah. First, Michelle said, didn't the judge also say BK's rights weren't violated by checking those databases because his relative's DNA in the database and not his? So the only person whose DNA it was could make the argument. Theoretically, yeah, he doesn't have standing to challenge the fact that his dad's DNA is in there. It's like, that's not your DNA. So his dad might be able to challenge it and say, hey, I picked this website because it said law enforcement can't search it, and his dad's not the one raising this issue, so therefore he doesn't have standing to do it. Yes, that is one of the arguments as well that we read through. I think you might have asked this before I read through part of that, but that's no problem. Okay, let's start here with the bottom of page 1. Through 6 different motions, because here's what this motion is about. Through 6 different motions, defendant seeks suppression of evidence gathered by law enforcement through these warrants on several grounds. His arguments for each motion have largely been disposed of through the court's contemporaneously filed orders, meaning the last order we just read, and some of the other ones we're going to read, he cites by reference here, he includes by reference. Still remaining, however, is 1, whether suppression is warranted due to law enforcement's failure to knock and announce in executing warrants at the Kohberger residence, and 2, whether the defendant's post-arrest statements are susceptible as fruit of the poisonous tree and or due to a Miranda violation. So people were wondering. So the knock and announce, did they leave enough time? They broke down the door, et cetera, et cetera. We're going to talk about that. Number 2, did he confess? What are these post-Miranda statements? Thank you so much, Netwoman, for gifting 20 memberships. Gaining a bunch of new Kohberger members today. So that was a big thing when we read some of these motions. What were the statements? Some of this stuff is under seal. What did Kohberger say? Is this where he said, was anybody else arrested? Did he admit to anything? That's pretty important. So we're going to read into that. A suppression hearing on the portion of the defendant's motions at issue here was held on January 24th, during which the court received testimony from Detective Corporal Brett Payne and Detective Lawrence Mowry, both from the Moscow Police Department. The court found both detectives to be credible and reliable. Following argument, the court took the matter under advisement. The court finds suppression is not warranted because 1, exigent circumstances excused the abbreviated knock and announce, and 2, the defendant has not established a Miranda violation. So let's talk about why. Starting with page 4. So this is when they went to Kohberger's house, what they were doing, why the knock and announce was either, abbreviated or not up to what it should have been. During their final preparations, CERT snipers set an umbrella around the residence to monitor any activity therein, while a helicopter monitored from overhead in the event the defendant exited the residence. At 12:33 a.m., snipers observed a kitchen light turn on and saw a taller, young, white male wearing a black hoodie standing near the glass sliding door leading out to the deck. And all these details are going to be important as to why they were able to not knock and announce like maybe they should have. At 12:40 a.m., the same person was seen again. This time, officers were able to positively identify the person as defendant. At 12:55 a.m., the light turned on in the garage where the defendant's vehicle was believed to be parked. At 1:03 a.m., lights flashed in the garage as if the vehicle was being locked or unlocked by a key fob. At 1:09 a.m., the defendant was seen in the kitchen of the home, this time wearing rubber gloves and handling a plastic baggie. So you're starting to understand why this is important, right? If you know why they can enter without knocking and announcing. Based on these observations, law enforcement believed the defendant was potentially destroying evidence from the vehicle that was related to the homicides. They knew about the vehicle. They knew about the defendant at the time. He's wearing rubber gloves, a black hoodie, taking plastic bags, all at 1 o'clock in the morning. Law enforcement was also aware of the defendant. So that's exigent circumstance number 1, is that if you're destroying evidence, the cops can bust in and stop you so that you don't destroy any more evidence than you're already destroying, right? But there's another reason. There's another exigent circumstance. Number 2, law enforcement was also aware that the defendant possessed a Glock handgun, prompting a concern over officer safety due to the defendant's heightened mental state of awareness or threat level of police possibly tracking him. Thus, law enforcement made the decision to shorten the knock and announce when executing the warrants. At approximately 1:14 a.m., CERT made an announcement from a Bearcat parked in the driveway of the residence. Immediately following the announcements, CERT effectuated a forced entry into the residence. Defendant was arrested without incident in his bedroom. His vehicle was located and secured in the garage. Once apprehended, the defendant was... Okay, I'm going to wait to read that part. Okay, so that is why those are the exigent circumstances. And to me, the judge made the right decision here. Those are exigent circumstances where you can have an abbreviated knock and announce before you enter, because we don't want people destroying evidence and we don't want cops entering an unsafe or creating a situation that's more unsafe than it needs to be. But what I will say, and what I hate, is it is so easy to make certain arguments that, and maybe that's just, and it is just like that some way. If somebody has committed a dangerous crime or there's probable cause that somebody has committed a dangerous crime, there's always the heightened level of officer safety. And I do think it should be that. But it's not really that hard to get there. right? To just say, here's the guy and we know he owns a Glock. Therefore, officers could be in danger. They could have just said, we have probable cause to believe he committed 4 very brutal crimes. And so we were afraid for our safety. That's not usually enough to get it done. Just alone the crime that you're charged with is not enough to get it done, but it can become an aspect of a totality of the circumstances, which it is here, right? Ashley said they could just say that too, though. And that's really what happens in a lot of cases, which is why I do think rubber gloves, plastic bags going back and forth from the car, that's a better argument, more specific to this case of potentially destroying evidence that makes it an exigent circumstance. That is how I see it. And again, I think the officer safety was fair enough, but I like that there was more than just that so that we could make sure that the exigent circumstances did exist. And I do tend to agree with that with the judge. Kate asked, why didn't they try to get him when he was out running? I don't know. I don't know the answer. And maybe they will ask that question. But again, if the defense is going to try to present this to a jury and they say things like, we have this local ordinance, you have this internal protocol and policy, you busted down his door and he didn't do anything. He was just sitting there. This kid that has done nothing wrong because he's innocent. And presenting that to a jury to try to say police bad, and this is another bad thing they did, busting down his door. This one to me doesn't have a lot of negative consequences for the defense. They can probably present that to the jury and say, look at what they did to his house. And, they found nothing. So they can make those kind of arguments. I think when they talk about, well, they used this database and they shouldn't have, but it matches DNA, there are some negative consequences to those questions if you follow me. All right, let's talk about the conversations now. Did they violate Miranda? Should the statements be suppressed? Once apprehended, the defendant was handcuffed and placed in a police vehicle. He was notified that he was in a police vehicle and being audio and video recorded. So they said he was notified of that, hopefully on body cam, which he acknowledged. While awaiting transport, the defendant informed law enforcement that he had an unloaded Glock 22 handgun in the residence by his bed. During transport, the defendant engaged in small talk with the accompanying officers. When the defendant expressed at one point that he wanted to know what was going on with his arrest, law enforcement told him investigators were going to speak to him at the station about the situation. The details of the investigation were not discussed with the defendant. Once they arrived at the station, the defendant was escorted into the processing room to await interview with Detective Payne, which occurred 10 minutes later. The defendant was then informed of Miranda rights and an interview subsequently began. So some new information here. Number one, he told them he had an unloaded Glock. Number two, he made small talk. Number three, he wanted to know what was going on with his arrest. Now, what we don't know and what is not included here is what questions were law enforcement asking him, because the judge ends up determining that this did not violate Miranda because this was not custodial. It was not a custodial interview. He was in custody, but they were not asking him questions in an interview style that could lead to some incriminating material. Instead, he was the one initiating conversation, volunteering conversation. So that's what the court ends up coming down. But I would like to know what questions were asked. Number one. Number two, after his Miranda rights, an interview began. It doesn't say what was said in the interview. It doesn't say that he invoked his Fifth Amendment right to remain silent. It doesn't say that. It doesn't say he shut it down immediately and said, "Where's my lawyer?" It said an interview began. Isn't that interesting? So there was an interview with Brian Kohberger that the defense wanted to get suppressed. Very interested to hear what that was about. There are two issues before the court: whether law enforcement failed to comply with the knock and announce rule, and whether the defendant's post-arrest statements are susceptible as fruit of the poisonous tree due to a Miranda violation. Okay? Those were the two main questions that the judge ended up answering no to both, and we've kind of gone through most of that analysis. We're going to read just a little bit more on page 10. The state does not dispute the defendant was in custody when first detained. However, there is no evidence before the court that the defendant was interrogated at any point from his arrest to the time he was formally interviewed by Detective Payne, at which point he was Mirandized. So he made statements. He was in custody, but he wasn't interrogated. At least not until after Miranda was read. And once Miranda's read, there's no Miranda violation. The sole evidence is that the defendant engaged in small talk with officers, with the only exception being he briefly asked about his arrest and was told that investigators were going to speak to him at the station about the situation. Voluntary or spontaneous statements or questions unprompted by interrogation fall outside the scope of Miranda. I would agree with that. I would just like to know what the statements are. I would also like to know, is the state going to use those statements? Because are they incriminating? Are they going to use them? Because that's important as well. Are they material? Are they prejudicial? This case continues to leave questions unanswered. All right, let's get to the last document, the Franks hearing. Oh boy, there's a lot here. We'll see how quickly we can cover it. All right. Frank's hearing. Let's start with the introduction. Defendant is charged with 1 count of burglary, 4 counts of M. We read all that already. The defendant is requesting a Frank's hearing, claiming law enforcement intentionally or recklessly misrepresented and or omitted several material facts in their probable cause affidavits supporting various search warrant applications. These misrepresentations or omissions, according to the defendant, affect the validity of 17 different search warrants. If you guys remember, we read through a Frank's hearing in detail in the Richard Allen case, and it was deplorable and horrible, and seemingly a Frank's hearing was more than necessary in that case. Judge said no. But I will say there are issues here, but it's hard when we come with a frame of reference. Sleuthy said, Bill Thompson, the prosecutor, said he didn't say anything too incriminating. But I do my best to not make my frame of reference the Richard Allen case, right? It doesn't have to be as bad as the Richard Allen case in order to get a Frank's hearing granted. So we'll just start with that. The state responds that the defendant has failed to make the requisite substantial preliminary showing under Frank's that 1, law enforcement either made false statements or omitted material information knowingly and intentionally or with reckless disregard for the truth, and or 2, that the false statements or omissions were necessary to a finding of probable cause. Okay, so this is our frame of reference. It has to be they did this knowingly and intentionally or with reckless disregard. Not like, oops, it's like I should have been so obvious and I still said no. And it can be a false statement, meaning a lie or something that's not true, or an omission, leaving something out. And that's important because there's some of that in here. But lastly, that the false statements or omissions were necessary to a finding of probable cause. And a bit of a spoiler alert here for you. This judge seems to think that this case clears probable cause by leaps and bounds, because throughout he talks about all the evidence stacked against Brian Kohberger. The DNA, the car matching, the pinging, the cell phone information, casing the joint, bushy eyebrows, the description by DM, which matches his description, where he was going in the vicinity, etc., etc., etc. The judge constantly mentions all of those things, stacking up the evidence as if he believes there's a lot here against Brian Kohberger. He seems to mention things we all already know about. I'm wondering if he knows about more, which is why that seems to be coming into play here, where he thinks this is an easy decision. And basically, at the end of the day, he thinks none of this matters because there was plenty here for probable cause. And that's what it feels like as a vibe throughout this entire motion. But we're going to read some of it. One of the things is officers are a lot like saying, I did this or we did this. And the defense is like, well, this officer said they did it. When that officer said they did it, the judge said officers are allowed to kind of do it together and swear to something together. Bottom of page 8 here. The second alleged misrepresentations are in Payne Exhibit A, supporting defendant's arrest warrant application. Defendant claims that both detectives simultaneously claim to have done cell site location information work, as well as to determine whether the defendant's cell phone was in the area of King Road residence. The defendant notes, however, that both detectives admitted at a subsequent hearing in this matter that it was actually the FBI cast agent Nicholas Balance who performed the location work that the detectives then used to complete their respective affidavits. That Agent Balance was the individual who actually did the location work does not render the detective statements intentionally or recklessly false or even misleading. While the defendant asserts that the detectives both claim to have done the work, they do not. They state that they were able to determine the locations after consulting with FBI CAS. Words are important. Definitions are important. The defendant thinks it says one thing. Judge says he thinks it says the other. And that it's not that big of a deal to say, I did the work if somebody else did it, because I didn't say I did the work. I said I determined something, and I can determine something based on somebody else's work. Both detectives explain in their respective affidavits that CAST was the FBI Cellular Analysis Survey team. Thus, it was made abundantly apparent to the magistrate that the detectives were relying on the work performed by a more specialized law enforcement agents in determining the cell phone locations. So what we think, right, and what we want to argue, and if we want to pick apart and parse this stuff at this point, and that's what the defense attorneys are going to do, that's their job. This is how the judge sees it. And because the judge sees it this way, as a matter of fact, that is what it is. This case is based on the lay people not understanding how easily trace DNA is transferred. This should terrify anyone who's ever touched anything that's not currently in their possession. I mean, I will say I don't think it's just that. I don't think it's just the trace DNA, but I do agree with you that trace DNA is not an exact science. It doesn't necessarily mean somebody was somewhere. It doesn't even necessarily mean somebody touched something, but it is like a locked and loaded. You might as well lock somebody up and throw away the key if the state is able to put up the fact that they have this trace DNA. It is so damning, and the prejudicial effect it has on the defendant, we really need to be careful about how we deal with this stuff and how technology can be sometimes scary because it is used as such an exact science and such a slam dunk when many times it is not. And that is the scary part. This is a side comment just to correct the record. It's UG Underground Mining. Okay, my bad. You said mining because I can't read. It's my bad. Alaska. It's the little things that keep me coming back here. Love the chat. Thanks, Peter. Yeah, no, you're good. I just can't read sometimes. I don't read good, you know. Thank you, Netwoman, for continuing to bring in the members. All right, what's next here? All right, challenging DM's memory. Let's go to page 13 here. So this is them challenging where the state's saying that basically there wasn't enough information about how unreliable DM's ID of Brian Kohberger was and everything that she said. They should have put more information about that. It could have led the magistrate to believe, oh, this isn't that reliable, therefore not enough for probable cause. All right, there's no evidence law enforcement intentionally or recklessly omitted information bearing on DM's reliability or that such omissions were material to probable cause. Defendant next asserts that the probable cause statements omitted important information bearing on DM's reliability. Defendant notes that DM qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mowry everything was kind of blurry, like I don't fully remember it, I would say. A few days later, while recounting the events to Detective Gooch, DM said, again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like half of this stuff, I don't even know if it's a dream or if it's real. I just have no clue. Obviously, that's not great. That's not very strong testimony. She said her memory was fuzzy and cloudy, and she could not differentiate if anything is real or if anything is in a dream. This information was not included in exhibit as according to the defendant, this information was crucial to allow the magistrate to properly evaluate DM's reliability, and its omission was material and exculpatory. The law does not favor the defendant on this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decisions, whether given all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying the hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. What's funny is it even says in here the veracity and basis of knowledge of the person supplying the hearsay. So here's how we look at this. Number one, oh, this is good. Alexander said, you are misleading your followers. Okay, Alexandra. Okay. That's one way to see it. It's one way to look at it. If that was my goal, man, it'd be tough because there's lots of people in here that disagree with me and lots of people in here that know every aspect of every case we talk about. There's lots of people that know way more factually about these cases that people dig into. What we're doing now is reading what the judge found and why the judge found it and describing what the case law says and how the judge applied the case law to the facts in this case, because he is the fact finder at this point. Okay, let's make sure we understand that. Not us. We are not the fact finders at this point. So what's interesting about this, okay? Number one, you can say stuff like, this is good fodder for cross-examination. When they call DM, if they try to use DM at trial and DM says X, Y, and Z, my guess is DM's going to admit she was drunk and maybe this could all be a dream or not. And the defense can talk about how you don't know this, you don't know that. It could be a dream. You were drunk. Your mind was doing all sorts of things, right? And she's going to have to say yes. And then a jury's going to have to determine whether or not they believe her or not. What I want you to understand too about these affidavits and about search warrants and about arrest warrants, right? How much power do prosecutors and law enforcement officers have? Because I'll just tell you, in reality, does it matter? Yes. And will she be rigorously crossed? Yes. But do I think this would have mattered one bit if they would have put this information in the probable cause affidavit? They could have said she was drunk and hazy and it could have been a dream, and the magistrate still would have signed off on it, if you want my opinion. Probable cause is such a low bar these days. You should know that by watching these cases and paying attention to these cases. They overlook so many things and they're just like, yeah, sounds like he's the bad guy, and they sign off on the probable cause. That happens all the time, which is why I will pound the table over and over again for how high of a burden beyond a reasonable doubt needs to be at trial. This is why it is not as hard as it seems to be sitting in the defendant chair, arrested and prosecuted. Now, the majority of them are guilty. The majority of them did commit crimes, but the ones who didn't sit there the same with the deck stacked against them. Okay? Azam, I might have missed this. Is this still about touch DNA on the sheath, or did they find actual DNA at the crime scene? If they went over to his garbage to match his DNA, isn't it fruit of the poisonous tree? So yes, the only DNA, as far as I'm concerned, that they have of his at the crime scene is touch DNA on the sheath. Now, they swabbed his cheek. Once they had him in custody, they searched his dad's trash for DNA and got his dad's DNA. They searched these genetic databases for DNA to match everything together. So there's different aspects of DNA, but as far as I know, the only DNA of his at the scene was touch DNA on the sheath. Okay, let's get back into this. I got sidetracked there for a second. Also, the judge, by the way, this is a bit concerning, but multiple times, the judge said he thinks DM's testimony was consistent. He thinks it was fine, basically, and he thinks it was reliable enough. It's like, okay, I probably wouldn't have thrown my stamp of approval on there, but it is what it is. All right, let's go to his summation here on page 15. In sum, the defendant has not shown that DM's various qualifications to her memory are material. It's like, they feel material to me, right? They feel material to me. Exculpatory facts that were intentionally or recklessly omitted and that would have affected probable cause. Now, I do agree with the last part. Unfortunately, I don't think it would have affected probable cause. It is evident from the applicable Exhibit AS that DM's account was largely relied upon to establish the timing of the homicides and general description of the perpetrator, not to identify the defendant specifically, because, in fact, she could not identify Kohberger when she was shown a picture. Her statements on these matters were consistent. While any perceived weakness in her perceived weakness, you should say any admitted weakness, because she admits the weakness of her own testimony and memory. While any perceived weakness in her memory may be fodder for cross-examination, they do not negate probable cause. So again, so many things, it almost feels like there's too many things where it's like, on its own, would this be enough? Probably not. But with everything else, totality of the circumstances. Let's see. All right, the next thing they get into is the vehicle info. The defense wanted them to put in the affidavit that the FBI specialist was more comfortable with the Elantra body style from 2011 to 13. They expanded it to 16. And we know his model fell outside that 2011 to 13 parameter. Judge says basically it's immaterial. I tend to agree. Just because somebody was saying something or thought something, you can use that on cross. I don't think it would have made a difference in probable cause. And people are going to disagree with me on some of this stuff, and I get it. But hi, Peter. Are you aware of any death penalty case in which the defendant chose a trial by judge versus jury? If the judge hears all pretrial motions, including inadmissible evidence, how does that work? They have to put it out of their mind. They can only consider what comes before them in trial. They turn a switch off and they become jury and judge at that point. It's very difficult. I'm not aware of it. I'm sure it has happened. I'm not aware of it. I would never advise it, number one. Number two, I'll tell you right now, I feel like we already know where the judge would go in this case. Yes, he applies a different standard for probable cause, and he even says how low of a bar probable cause is. He would definitely apply beyond a reasonable doubt, but would not look good for Kohberger at this point. Thank you so much, Azam, for gifting 10 memberships. All right. The next thing is the detective's timeline is misleading because they want to download or downplay how important the IgG information was. Let's go to page 21. We're working our way through here. In neither example has the defendant established Detective Payne's investigation timeline to be misleading or false, much less intentionally or recklessly so. There can be no question that the defendant was identified in part through the WSU officers' queries and through the suspect vehicle's lack of front license plate as observed in surveillance videos from the night of the crimes. The fact that law enforcement had additional DNA evidence tying the defendant to the crime does not render it improper for law enforcement to rely on independent evidence accomplishing the same. It would arguably be irresponsible for law enforcement to rely solely on DNA evidence without making an effort to corroborate it, particularly given the novelty of IgG. Everybody agrees on the novelty, but it's coming in. And it will be the most important piece of evidence, in my opinion. The defendant has not established there is anything wrong with this approach. Observing that requirement under Franks, that search warrant affidavit be truthful and complete, does not require that every fact recited therein be correct, or that every detail of the investigation be provided. How about that, right? How much do we care about the accused? Every fact doesn't need to be correct. It's like, it's okay. Now, they say that because if there's some immaterial fact that's wrong, I agree. But every material fact should be correct. No doubt about it. Indeed, what is important to probable cause is the totality of the evidence once all gathered and examined in the light of what that collection of evidence shows, not looking at it in isolation as each piece of evidence was separately gathered. Giselle, random, but my brother looks like he could be your son. He's 20 now. Can I send you a pic of him so we can do a poll and see what everyone thinks? You can send me a pic. I'm not sure we'll do a poll. I don't think we'll have time for a poll today. Unfortunately, I'm over an hour and still have 17 pages to summarize and read, but that's funny. That's cool. Moreover, had law enforcement indicated in Exhibit A that the Washington State query and lack of a front license plate only came across its radar after the defendant had been identified through IgG, the defendant has not explained how this would have eroded probable cause. Indeed, as discussed below, including IgG evidence would have provided more, less probable cause supporting the search warrants. Consequently, a Franks hearing is not warranted on this issue. So this is an important point. The defendant kind of makes these arguments throughout that the IgG was so important. They wouldn't have been able to do any of this with IgG. And because of that, this should all be fruit of the poisonous IgG tree. This should all be thrown out. It should all be suppressed. What that is not necessarily a Hail Mary, but it's kind of like the root of the tree. The IgG was the root of the tree. They make arguments that each branch of the tree is poisonous, but they make the main argument, and they felt their best argument was with the IgG because of its novelty, because the FBI violated their internal policy. That's what they felt like was their strongest argument. So they tried to attach as much to that argument as they possibly could. And if they would have won on IgG, then they start to have better arguments on all these other factors. But because the judge has already told them they lost on IgG, and he's going to tell them again at the end of this document, he's now thinking of it as IgG. They could have put it in the search warrant. The IgG was fine. Law enforcement should have added it to the search warrant. They should have added it to the affidavit because it would have added to probable cause. That's great evidence against Kohberger. So the fact that you're saying they couldn't have done all this without IGG, they could have done it with IGG. So the argument has kind of flipped on them now. Now that they lost IGG, it actually becomes worse for them. But the reason they were throwing this out there and connecting all this to IGG is because they thought, if I would have won on that, we would have won on all these other issues too. So that's kind of why the judge keeps saying, like, well, you made this IGG argument, but it's not even that good of an argument. That's why the defense did it, because they didn't know they were going to lose on IGG at the time they were making all of these arguments. Next is the dog barking. So there was dog barking, and they say that the cops didn't do enough of an investigation on it. Where is it? What was I going to read? The defendant contends that the Detective Payne failed to include 3 allegedly important pieces of information. So this would be another omission in the affidavit to the dog. That the dog heard on the security camera continued to bark for 30 minutes after the suspect left. That Detective Payne conducted a test to determine that the dog was likely outside while barking, and that Murphy was found without any blood on him, even though the bedroom doors were open where the detectives were found. According to the defendant, this omitted information would have revealed that whoever was in the house brought the dog back inside after the suspect vehicle left. He further argues this information is material and exculpatory because it undermines the narrative and the timeline that support probable cause. However, the defendant's argument assumes without proof that there were no doors left open in the home after the suspect left. This assumption is not only speculative, but contrary to the evidence in his proffer that the sliding glass door to the residence, the same door which DM reportedly saw the suspect walk, was left open. Thus, if the dog heard barking was in fact Murphy, it could well have come back inside through the open door and had gone into Miss Gonzalez's room on its own, where it evidently remained. There is simply no evidence to adopt the defendant's speculation that someone brought Murphy inside after the suspect left the residence. Consequently, the defendant has not shown that the failure of law enforcement to so speculate was a material and exculpatory omission that was intentionally or recklessly excluded. Frank's hearing is not warranted on this issue. So there are multiple times throughout this order where the judge basically says, either I don't believe you, defense, in your argument, or your speculative and conclusory statements are not enough. Just because you say it doesn't mean it's true. Just because you say it doesn't mean law enforcement knew it at the time, believed it at the time, or should do anything with that information. He ain't giving the defense any benefits of the doubt. At what point does a technical defect in a search warrant become grounds for suppression? That's a question for a judge on an individual case, because people probably have different lines on that. What level of omission or falsehood is required for a court to grant a Franks hearing? Was the denial here justified? So I read the exact language. I don't have it up anymore, but it's basically, it has to be, if you go back in the video, I read the exact language verbatim, but it's basically, it has to be an intentional falsehood or omission, or a reckless disregard for the truth when entering a falsehood or omitting very important facts that are material in proving probable cause. So if you intentionally lie or intentionally leave something out, but it isn't material and there would be probable cause even without it, not necessary for a Franks hearing. If you accidentally leave something out that may be material, not enough for a Franks hearing, even if it was material for probable cause. So that's it, both elements. Wanted to say this during the Rocky trial, but couldn't catch a live. John Lewin is the LA County prosecutor who recommended the dog bite expert for Karen Reed. Ain't that funny? Ain't that funny? I love getting connections between cases. And Ben Chu and Camille Vasquez represented the victim, apparently, or still do. Really. All the connections. Okay, let's keep going here. We're almost done. The geofence data. Judge says the defense argues they speculate as to when criminals turn off their phone. That doesn't meet the Franks standard for recklessness, because the cops say, oh, this is when defendants or criminals usually turn off their phone, things like that. Let's read the little section here. The court does not find the defendant's proffer deserving of a Franks hearing. First, the defendant has not established the challenge statement is a misrepresentation. Detective Payne expressly qualified his statement by noting it was an approximation only. As he testified to an earlier hearing in this matter, Detective Payne is not an expert on deciphering CDRs. Thus, he provided the records to the FBI Special Agent Balance to analyze and relied on Balance's analysis. Affidavit disclosed both Payne's reliance on Balance's analysis. It's like, what is that? There's a rhyme that's coming to my head, but I can't think of it. Balances training experience. To the extent an approximation was off, a 7-minute discrepancy, particularly one occurring more than 1 hour prior to homicides, is not so far outside the approximation window as to render the statement false. Again, it's like, 7 minutes. He said it was an approximation. 7 minutes can be a very big deal depending on the timeline. Think about 7 minutes in other timelines of cases that we've watched and listened to together, like Karen Reed's trial. 7 minutes can be incredibly important. I think 7 minutes could be incredibly important in this very case. To the judge, he says NBD, no big deal. Further, even if the statement could be characterized as false, the defendant has not shown it to be intentional or reckless. In fact, not even Mr. Slavinsky goes so far as to impute this mens rea to Detective Payne. Rather, he points out that Detective Payne either disregarded or was unaware of the handoff data that would have revealed the correct time the phone stopped reporting. Okay, so it wasn't intentional. All right, cell tower coverage. Let me read a little snippet on that. Let me know what you guys thought of this. Usually I don't just kind of summarize and read snippets. It was the only way I was able to get all of this information in, and even that I wasn't able to get for, and even doing it this way, I wasn't able to get it in under an hour. But let me know if you prefer me to read the entire document. We could do it in multiple parts, and it'd take a lot longer, obviously, but this stuff all kind of went together, and the overarching themes were more important than the individual decisions, in my opinion. The accusation here is one of omission, specifically whether Detective Payne recklessly or intentionally withheld from the magistrate that the same towers providing service to Kings Road also provide coverage to all of Moscow. So basically, they were saying they were acting like it means he's at Kings Road, but he could have been a lot of different places if he pinged on this tower. There is no direct evidence that Detective Payne intended to mislead the magistrate, nor can it reasonably be inferred, given the detective has not shown the omission to be material and exculpatory. So you're also hearing all of the different ways that you can say, no, not enough for a Franks hearing, right? We've heard it wasn't intentional. We've heard it wasn't reckless. We heard it wasn't material. We heard it wasn't have led to it not being probable cause. We've heard it being an estimation or approximation, which is not intentional if it's wrong. And now we're seeing the same thing, that he could have done it on purpose, but there is no direct evidence that Detective Payne intended to mislead. So now you need this direct evidence in the judge's estimation to be intentional or reckless, because you have to prove it. The defense has the burden to prove that in this case. They found 0 victim DNA in his car, which they say he drove to the crime scene or apartment. They can't have it both ways, trace versus blood DNA. Well, they're going to have arguments for it. The state's going to have arguments for that. And the defense is as well. And this trial is going to be incredibly interesting to me. It really is. And I'm interested I hope the jurors give interviews after, because I want to know how they parse all of this stuff. Because there's going to be a lot of technical experts in this case. And a lot of things that could be confusing that I hope they don't just throw it all out and say, we feel really bad for these victims. I hope they hold the state to the burden. If the state does prove it beyond a reasonable doubt, I hope they convict Kohberger. If the state doesn't prove it beyond a reasonable doubt, I hope the verdict is not guilty. Netwoman, 10 more. That's awesome. 10 more for overtime. We're almost done here. Did I finish reading this? While including the information may shed some doubt on whether the defendant was actually in the vicinity of Kings Road on these 12 occasions, as opposed to some other nearby location, it does not disprove Detective Payne's statement or otherwise exculpate the defendant. Given the breadth of exculpatory evidence included in Payne's Exhibit A, it is difficult to ascribe ill intent to this alleged omission. Further, and importantly, probable cause did not rise and fall on the evidence of defendant's 12 prior visits to Moscow. Yeah, it might not have risen and fallen on it, but you keep mentioning all these little things. It's like, this wasn't the big deal of probable cause. It's totality of circumstances. Well, how many of those circumstances should you remove? That's an honest question, I think. That is an honest question. All right, footprint, DNA. There's nothing false or misleading about Detective Payne's statement. The shoe print was consistent with DM's account. She told law enforcement she saw a defendant walk past her bedroom door after she opened it for a third time. I think he was walking past my door and like saw me. I would say he was about 3 feet away from her. DM's bedroom door is immediately at the landing at the base of the stairs leading to the upstairs bedroom. The shoe print was therefore reasonably within the suspect's path of travel as described by DM. Further, the fact that the footprint was located only in one spot and there were not others before and after does not make Detective Payne's statement false about the path of travel. Consequently, the defendant has not shown Detective Payne's statement was false. Additionally, defendant has not established that DM's interview statements were wholly unreliable. They were pretty unreliable, but I don't know if they were wholly unreliable or that there was otherwise a need to bolster her credibility in the magistrate's eyes through false corroborations. Consequently, even if the shoe print was not totally consistent with DM's account, defendant has not demonstrated that the statement was made deliberately or recklessly. It's like, even if this was totally false, you didn't show that it was deliberate or reckless. And I'm not joking to say this judge is corrupt. I'm using a bit of sarcasm so that you guys show that it is so difficult to clear these bars as a defendant. So difficult. Frank's hearing is not warranted here. All right, I got to run here soon. The lack of the victim DNA in the car. Did basically the judge like, well, did law enforcement even know about the lack of DNA, the victim DNA in the car when they did the probable cause affidavit? Maybe they did. But if they did mention it, would that really change anything? Probably not. That's what he says. There's enough here for probable cause. I'll read one paragraph just to give you a little example about how he's like, there's plenty here, plenty here. Further, the defendant has not demonstrated how including this omission, meaning the lack of the DNA of the victim in Brian Kohberger's car, like they didn't put that in the affidavit. But was that a big deal? The judge says he contends that it would affect all warrants issued January 5th and beyond, but he has not provided any search warrant affidavits from this period for the court's consideration. So it's like, if it was going to affect those, you should have given them to me. However, based on the Payne Exhibit A that is issued by Defendant's proffer, the probable cause as of December 29th included, among other things, okay? So it's like each individually kind of unreliable, but look at all this stuff they have. The DNA profile obtained from the trash pull of his family trash was determined from a biological father source DNA left on the knife sheath. Bada bing, bada bang. That's how important it is that it renders all this other stuff a lot less important. Given this evidence, given the fact that the touch DNA is on the knife sheath, which is locked and loaded to this judge, no reasonable magistrate would conclude that the lack of victim DNA in the defendant's vehicle and or apartment weeks after the crime would negate probable cause. So because of that, it really doesn't matter what else you have. You're going to have probable cause if you've got his DNA on the knife sheath. That's what it sounds like to me. All right. The defendant's identification by IgG. I'm just going to do this quick because we've already talked a lot about IgG. Franks, in case of omission, asks simply whether the affiant left out evidence which, if known, would negate the inculpatory effect of the existing evidence and leave an insurmountable deficit in proof probable cause. Meaning, if you remove something, is it over? Is there not enough there for probable cause? The defendant has not established that omitting the defendant's identification through IgG evidence or the means in which IgG was performed had this effect. Indeed, had the IgG information been included, even with the problems complained of by the defendant, its only effect would have been to add probable cause, not detract from it. So he says, if they would have added in the fact that, oh, the FBI violated their own internal policy, but here's what the IgG said, it would have added to the probable cause, not reduced it. And so basically he's like, sure, remove the DNA. They still got probable cause. And the judge gave it to her, the magistrate gave it to him. But if you had added the IgG, it would have been even more. And because we had the IgG and the DNA stuff, removing something like no victim DNA in the car wouldn't have mattered. It feels like circular reasoning. It really feels like circular reasoning. Overall, obviously not good for Brian Kohberger. This stuff is going to come in. It's going to come before a jury. It's going to come before a jury in some sort of fashion. Now, there can still be more motions to suppress. There can be motions in limine. So a lot can still happen. It doesn't mean it's guaranteed to come in. But this was the big swing for the defense, and they lost. So they've got to regroup, come up with different ways to try to find why this evidence might not be reliable enough to go to a jury. It was reliable enough to use in the way that they did so far with the magistrate, but they still have other cracks to try to get it stopped and blocked before trial. I think they have a major, humongous uphill battle, not like what I call mountains in North Carolina, which everybody makes fun of me on every golf video. When I say mountain golf, you're like, that ain't mountain golf. I'll show you mountain golf. But much larger mountains than in North Carolina is what it feels like Kohberger has to deal with when it comes to getting this judge to find any of this evidence unreliable or to suppress it. Improv man, question: how many things get disregarded before the magistrate becomes a rubber stamp. Sometimes it feels like that with probable cause. Lola, it's kind of like how we know every prosecutor is going to win every preliminary hearing because it's just probable cause. Can you imagine if Judge Hippler swapped trials with Judge Bev from Karen Reed? My mind is blown. Thanks for all you do. Great summary within an hour. Yeah, I don't know. I would like to see that. I would like to see how he would deal with maybe more obvious issues with law enforcement and prosecutors. I don't know. All right. I see people saying there's new Karen Reed documents. If you want me to break them down, send them to me. You know where to find me. At Lawyer You Know on Twitter, at Tragos Law on Instagram. Send them to my DMs. I'll take a look at them. If enough people are asking, we will do videos on them. But I ran a little overtime again today. It seems becoming a habit. I really got to get back down to an hour. Hit that like button if you guys haven't. Make sure you're subscribed. I appreciate you all. Yeah, carrying a vacuum. That was interesting too. I didn't read that fact, but carrying a vacuum-like object. I definitely learned some new facts in this, but we didn't have time to necessarily focus on everything. But I appreciate you guys. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.